everyone. As Kevin said, my name's Kira, and I've been volunteering with the Epilepsy Foundation, I think almost 5 years now, definitely 4. And I got involved because I actually have epilepsy and wanted some resources. And our next speaker will be Amy Gilbrough, who will speak on the topic of Social Security disability. Amy is a partner with the law firm Douglas, Drachler, McKee, and Gilbrough. After learning her law degree at Lewis and Clark College, Amy began working at the Social Security Administration, working for the Office of Disability Adjudication and the Review of the Office of General Counsel. There, Amy built a foundation of knowledge in Social Security laws, processes, and had the opportunity to work with fine attorneys and dedicated public servants. In January of 2003, she began representing Social Security claimants. Since then, she has used her skills to pursue disability benefits for individuals at all levels of appeal before SSA, the Federal District Courts, and the United States Court of Appeals for the Ninth Circuit. This pairing of ideals and skills has resulted in a fulfilled attorney and hundreds of pleased clients. As a member of the Washington State Bar, the King County Bar, and a sustaining member of the National Organization of Social Security Claim Representatives, that's a mouthful, please welcome Amy Gilbrough.
Hi, good afternoon. Well, I'm going to be presenting on Social Security disability. First of all, what am I going to be talking about? Some people don't know that in addition to its retirement program, Social Security administers disability programs. These provide modest monthly cash benefits and Medicare and Medicaid insurance benefits to disabled individuals. So today, hopefully, when I get done with my 45-minute talk, or hopefully a little bit less so we can have some time for questions, hopefully you will understand what benefits are available through the Social Security programs, how Social Security defines disability, in other words, what is it? What are the criteria they use to establish disability, how the process works, and whether you really need a representative in your case or you can go it alone. What benefits are available? Okay, Social Security administers 2 main programs, the Social Security Disability Insurance Program and the Supplemental Security Income, or SSI, program. Social Security loves its acronyms, and I'll be trying to keep those to a minimum, and I'll also try to be consistent in my use of those throughout my presentation, but you can catch me on it if I screw up a little bit, because I'm used to talking in those acronyms all the time. So SSDI, or the Social Security Disability Insurance Program, is the benefit you earn through your work activity. Those are the benefits that are taken out of your paycheck each month when you receive that. These can be paid to the worker, the person who's actually paid for the benefit, but also the worker's spouse, a divorced spouse, a widow or widower, or a disabled adult child. The amount of Social Security benefits varies based on your lifetime earnings. People who have paid more into the system will receive a higher monthly benefit amount than people who have paid less. The average in 2017 is about $1,171 a month. This is a modest benefit. I think it maxes out this year at a little bit over $2,000. It's retroactive. SSDI can be paid up to 1 year prior to the date that you apply. So you can, and if your application is pending a long time, you can still receive benefits up to a year prior to the date you apply. If you're found eligible for SSDI, you can also receive insurance. SSDI beneficiaries become eligible for Medicare after their 24th month of receiving benefits. The other program is Supplemental Security Income, or SSI. This is a program for people who have for children or for people who have not paid enough into the Social Security system to be eligible for SSDI. It's paid to disabled children and adults. Applicants must meet fairly significantly low financial criteria. This is a need-based program. In 2018, the maximum individual benefit amount is $750 a month. That's for children or adults. There's no retroactivity. SSI starts the date that you file your application. And individuals who qualify for SSI are also eligible for Medicaid. So those are the two programs. Now, how is disability defined? No matter what program you may be eligible for, an individual may be eligible for, an individual needs to prove disability, and the definition is the same under either program. One thing that is not mentioned in my slides, but I want to talk about for a moment, is that you either are disabled or you're not disabled under Social Security's programs. Every once in a while I get a call from someone who says, I'm partially disabled. I just need a little bit extra every month. I have this significant problem. That's not the way that Social Security disability works. You either are or you're not. You're either eligible or you're not eligible. There's no in between for them. Disability is the inability to perform substantial gainful activity due to an impairment or combination of impairments for a period of at least 12 months. Now this is the adult definition of disability. I am going to talk about some criteria for child disability, and I can also answer questions for that at the end of my presentation, or I will wait until after the presentations are done. If you have specific questions about your case, I'd be happy to answer that. But I'm going to focus on adult disability because that is the majority of the work that I do. Notice that under 2, we talk about an impairment or combination of impairments. If you have a problem in addition to epilepsy, that also should be considered by Social Security in making a determination of disability. Sometimes people call and they talk about how they want to get disability based on their back, but they also have a problem with depression, or they have other significant physical or mental health issues that contribute to their inability to work. You don't have to just be found disabled based on one thing. Social Security looks at you globally as a person and determines whether you're disabled based on your combination of impairments. Has to be for a period of at least 12 months, but what that means is this doesn't have to be a lifetime benefit that you're receiving. People who are only disabled for 12 months can receive Social Security for that 12-month period, so that's important to keep in mind. Talk a little bit about substantial gainful activity. If you remember from the last slide, an individual needs to be unable to perform substantial gainful activity in order to be eligible for Social Security benefits. What this means is that generally, if an individual is working and earning $1,180 a month for 2018, this shows that the individual is engaged in substantial gainful activity. If you are working and you are earning $1,180 a month, you're not disabled, no matter how severe your medical conditions are. The only exception to that is that there are a few exceptions. If you have an impairment-related work expense that reduced your earnings under $1,180 a month, you could be found disabled even though you're working. Impairment-related work expenses are things like if you have to pay a driver to get you to work because you can't drive, or if you have to pay for a special piece of equipment in order for you to work, this will reduce the amount that you're earning. But otherwise, if you're working and thinking about applying for Social Security disability, you have to stop. It's a leap. You have to stop working and then you can apply. They won't find you disabled if you're working. If you're not working, there are essentially 2 ways an adult can establish disability under the rules. Number 1, an individual can show that their conditions meet or equal a medical listing, and I'm going to talk about the listings, begin talking about the listings in the next slide. Number 2, the individual can establish that the limitations are related to their medical conditions are so significant in combination with their age and education that the individual cannot perform full-time work that exists in significant numbers in the national economy. And I'll talk about that in a moment too. In terms of the listings are a set of regulations which provide symptoms and limitations where if you meet those criteria, you're so severe that you meet the qualification for disability without further findings. So basically, if you read the listing and you meet what it says in the listing, you're disabled. Okay. Remember, this isn't the only way to establish disability. You can also establish disability as an adult if you can prove that you have other limitations that maybe aren't in the listing that would prevent you from working. And as a child, you can establish you're disabled if you have marked limitations in certain areas which aren't addressed by the listing. So even if you don't meet a listing, you may meet the criteria for disability based on other rules. So a summary of criteria for listing 11.02, which is a listing that discusses epilepsy, is that number one, the individual needs to be compliant with treatment. So if for some reason this individual is non-compliant with treatment, for example, not taking medication as prescribed, they're not found to meet the listing even if they have the other criteria. This individual has to have tonic-clonic or dyscognitive seizures. Those are the terms that Social Security uses. This listing probably won't be changed for 10 years. It was just changed last year, and likely by the time that the end of the 10 years comes around, there will be another name for these types of seizures. But these types of seizures are described in the listing. Tonic-clonic are kind of major motor. One way to think of them is those are major motor seizures. Dyscognitive are minor motor seizures. I'm not a neurologist. I'm sure there are more specific terms for these, but I'm using the terms that Social Security uses in the listings. Psychogenic seizures are not included. This is a little bit of a gray area, and I'm interested to hear your presentation. Psychogenic seizures are not included in the listing criteria. They may be considered in determining whether an individual is disabled, just not whether they meet the listing. You must have seizures of requisite frequency, which I'll talk about in a moment, or for adults, you can have seizures less frequently, but with some accompanying functional limitations. So compliance with treatment is mandatory absent a good reason. Some examples from the regulations include if you have mental limitations that interfere with your ability to adhere to prescribed treatment, you have linguistic or cultural barriers that interfere with your ability to adhere with prescribed treatment, or financial constraints. If you can't afford your medication, you can't afford the treatment that's recommended for you, you may still meet the listing, even if you're not taking the medication that would improve your condition. If treatment is risky due to its magnitude, consequences, unusual nature, or other reason, especially if brain surgery is recommended or could improve your condition, that's not necessarily something that Social Security is going to require. Treatment is contrary to established teaching or tenets of your religion, that may be a good excuse. You previously had surgery and it wasn't successful, and now surgery is recommended again. You're not necessarily required to undergo surgery. Or, and I think this comes up a lot with seizure disorders, the side effects of medication are as debilitating as the seizures, where you're taking high dose of medication. Okay, so it may be that if you're not compliant with treatment, if there's a good reason, you can get beyond this particular criteria for meeting the listing and being found disabled. So the listing criteria for generalized tonic-clonic seizures. You are disabled if you're compliant with treatment and you have a seizure that occurs at least, a generalized tonic-clonic seizure at least once a month for at least 3 consecutive months. So if you're compliant with treatment and you have a seizure every month, you meet the listing. Or you have a seizure that occurs at least once every 2 months for at least 4 consecutive months. So in other words, in a 4-month period, you have a seizure every other month, and you have a marked limitation in physical functioning, understanding, remembering, or applying information, interacting with others, concentrating, persisting, or maintaining pace, or adapting or managing oneself. So Social Security just changed the regulations this year. They used to just look at the number of seizures you had and require that you had a seizure once a month despite compliance and treatment. They added this second criteria with the seizures once every 2 months out of recognition that people don't always go to the emergency room, or sometimes or when they have seizures, and sometimes it can be difficult to prove that a seizure is occurring every month. And so this gives a little bit of wiggle room in terms of kind of having an accurate count of seizures, but it does require that you meet this additional criteria of marked limitation in one of these 5 domains. The listing criteria for dyscognitive seizures will read similarly to the tonic-clonic seizure listing, except that dyscognitive seizures, which are less severe perhaps in terms of their impact must occur more frequently. So for dyscognitive seizures, the seizures occur at least once a week for at least 3 consecutive months, or once every 2 weeks for at least 3 consecutive months. Now, these dyscognitive seizures can be harder to count because, especially if an individual is living alone or they don't always have people around them, don't necessarily always know when these are occurring. And so this this counting mechanism where you need to show that they only occur once every 2 weeks can be very helpful in this case. I'm just going to stop for a minute. Does anybody have any questions on the listing issue? I went through that pretty quickly, and I know it can be a little bit confusing. Okay, good. All right. I can take your questions after if you're still formulating your question. Okay, what if a listing is not met? Oh, hold on. So for children, the listing is fairly similar to the adult listing, but for children, that is individuals under age 18, only the very top of the slide applies. So for generalized tonic-clonic seizures, a child is disabled if they have a tonic-clonic seizure that occurs at least once a month for at least 3 consecutive months. And for dyscognitive seizures, a child is disabled if they have a dyscognitive seizure that occurs at least once a week for at least 3 consecutive months. Yes?
Can those be challenged, or are they just, that's it, and there's no, like, for my daughter, it's the bottom one is more of her, she's 8, but the top wouldn't, so is that possible to challenge it, or
No.
that's it?
That's it for the listing. So remember, there's just like for adults, there's another way for children to meet a listing, and that is to show that they have a marked limitation in six domains. And so that may be more where your daughter lies. She has a seizure disorder, plus she has a marked limitation in the 6 domains, and those are acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself, and health and physical well-being.
And how many of those do they have to hit?
Mark limitations in 2 of the 6. Okay, so that may be more where your daughter lies. If you're thinking she meets that kind of beat criteria for adults, she may be in that area for parents, for children. Okay. So if a listing isn't met, the listings describe impairments that are so severe that Social Security doesn't need to look any further, basically. So these listings describe someone who is very impacted by their condition, whether it be epilepsy or schizophrenia or cancer, okay? There are a lot of people who meet the criteria for disability based on this alternate criteria, which is showing that the limitations related to their medical condition or conditions are so significant in combination with age and education that they cannot perform full-time work that exists in significant numbers in the national economy. So if you read those listings and they don't apply because seizures are in control or they're not occurring with requisite frequency, when you look at the whole person and all of the limitations that occur with the epilepsy, there may be some disability found, even if the listing isn't met. Here are some examples of symptoms imitations. That should be limitations preventing work activity. Fatigue due to post-seizure effects or side effects of medication that require naps or rest periods during the workday. If you have to sleep during part of the day or you fall asleep, you're not going to be able to perform regular, sustained, competitive, full-time work activity. This is something that comes up a lot and it's very significant. Flares of symptoms causing absences. If you have periods where you're unable to work where your absences would be unacceptable to an employer, you may meet the criteria for disability. Difficulty with memory or concentration affecting understanding, remembering, or completing work tasks. If you're unable to learn a new job, or if you have some difficulty with with completing work tasks due to problems with concentration, you may meet the criteria for disability. Difficulty dealing with coworkers or supervisors due to irritability. If you're going to lash out at people just because of irritability, and that's something that you can establish, you may meet the criteria for disability. Or lasting physical limitations due to post-seizure effects or other medical conditions you have. These are just examples. The sky is basically the limit in terms of establishing that you're unable to work due to the specific limitations that an individual has. It's one of the reasons why it's so interesting to be a Social Security lawyer, is sitting down with people and talking to them about the kinds of issues they're having and try to explain to Social Security why this individual person and the constellation of symptoms and limitations they have prevent them from working, and then trying to kind of gather information which helps them prove that. All right, so we've kind of talked about how to, what criteria Social Security uses to establish disability. And now I want to try and kind of walk you a little bit through the process so you understand how that works. Social Security basically has 4 potential administrative stages: the initial application, a request for reconsideration, the hearing level, and then a review of a decision at the hearing level. So an individual's case could basically end at any of these steps. Hopefully it will end after the initial application process and the individual will be found disabled. But if that individual is not found disabled initially, they can file an appeal and work their way through this administrative process. And as you heard in my bio, even if a request for review of hearing decision is denied, an individual can file an appeal in federal district court, in the Ninth Circuit Court of Appeals, and even go to the U.S. Supreme Court if they want to, although I can't help them with that part of the process. Okay. So the initial application, how to begin. Okay. For SSDI benefits, those benefits that you paid into when you were working, you can file an application for those benefits online at ssa.gov. So you can be sitting at home and do that. That's the easiest way to do it. You can also file in person at a Social Security office. I do not recommend that if you're thinking about filing an application, the very first thing you do is go into your local Social Security field office. I don't know if anybody has gone into a field office for assistance, but their hours are limited right now. There are long lines. So what I recommend is that you call the Social Security's 1-800 number. That will take you a little bit of time, probably 30 to 45 minutes just to get through to them. But then they will set you up with an appointment at your local field office where you'll just have to go in at the time of your appointment and you'll get to the front of the line. Okay. You don't have to file for SSDI online. You can go into your local field office and apply for any program. I just recommend that you call first so you don't get turned away because you're not in the right place in line. If you're connected with Department of Social and Health Services here in Washington, you can file at a DSHS office. Someone there can help you with your application. Or you can file with assistance from an attorney. People call me and say, isn't everyone denied the first time? You know, they hear from their friend or relative or provider that everybody gets denied the first time. They don't. About a third of applicants are granted benefits on the initial application. I think that in some ways, believing that you're going to be denied the first time can be a self-fulfilling prophecy. If you don't take the initial application process seriously and provide all that information that will allow Social Security to reach a finding of disability, then yes, you probably will get denied. But I think if you take the process seriously and you meet the criteria for disability, you stand at least a 1 in 3 chance of getting granted, and probably higher than that. Here's the information you need to file an initial application for Social Security. You need to know what your alleged onset date is, the date that you became disabled. It may not be the date of your diagnosis or the date of your first seizure. Remember that if you're working, you can't receive disability benefits during that period that you're working generally. So if you're working, you want to allege your disability began after the date that you stopped working. So that's one example of kind of a different onset date. You need to have a list, write a list of your conditions. If you don't just have a problem with a seizure disorder, but you have other issues, even if you don't think these are the reason that I'm not working, they may kind of cause some additional limitation, which may affect the types of jobs that you can perform. So it's important to talk about all of your conditions. You need to have information regarding your medical treatment and evaluation. I think this is one area where people often don't provide complete information with the initial process. So it's important to provide names, address, and telephone numbers of your treatment providers, anyone who's evaluated you, emergency room visits, therapists. If we're talking about a child or a young adult, information about where to contact the school to get information from special ed. All of these things should be written down in that initial application, because we'll talk about next, Social Security will go get that information that you tell them about. You don't have to go out and gather that for yourself. If you're an adult, you need to provide your employment history for the past 15 years, including the dates of employment and the rate of pay. Especially if you're applying online, you can't get through the process without filling in the boxes about this information. So you have to kind of have that ready to go. Otherwise, you won't be able to complete your application and it gets frustrating. Okay. And bank account information. Social Security has a direct deposit program. They like people to set that in place right at the beginning so that if you are found disabled, your check will go right into your bank account. After you kind of complete that initial application process, you either do that online or you go into the Social Security office. Social Security will review your earnings record to determine whether there are earnings after the alleged onset date. If there are, they have to kind of make a determination about whether that work would prevent you from receiving benefits. They'll gather the medical records they know about. So if you've given them information about where to get those records, they'll pay for those. They'll do all the legwork to go out and get those. You do not need to get those before you file your application. They will ask the Social Security claimant to complete forms that describe work history and functioning. The form that they send you to ask about functioning is the function report. It's I think it's the most important form. That is the information that you're going to provide to Social Security, which will show why you're disabled, why you meet the criteria for disability. For a seizure disorder, they may also send you a form that asks you about when your most recent seizures have occurred, whether you're taking medication, things of that nature. They may order a consultative examination, so if they feel like once they get your medical information, they don't have enough information to make a decision regarding disability, they may pay for and send you out to a consultative examination. And you shouldn't, a claimant shouldn't panic about this. Oftentimes these examiners will find people disabled. They're not hired guns for Social Security who will make a decision that you're not disabled. Many of these examiners will find that an individual has limitations that prevent them from working. Once they've gathered all that information from you and your doctors and maybe from a doctor that they hire, they'll send the records to a reviewing doctor who will review them and make a determination about whether you meet the criteria for disability. And Social Security will make a decision in as little as a week to as long as 6 months. For individuals with seizure disorders, generally speaking, it's not going to be a real quick decision. The individuals who receive benefits very quickly are generally people who have terminal illnesses, where they want to get people on benefits as soon as possible. So filing tips, allege the earliest possible date of onset. So, it's okay to make a little mistake in terms of saying when you became disabled. If you're in doubt, allege the earliest possible date, and then Social Security can kind of work out with you if your disability started later. Identify all your conditions, not just epilepsy. I think I've talked about that several times now, so I'll leave it there. Identify all your medical providers. Respond promptly to requests for information. If you don't provide the information within the time frame that Social Security wants, they may deny your case because you're not cooperating with their requests for information. And you can call the adjudicator at the initial level asking for status, or if something new has come up, like your seizures have increased in frequency during the period that Social Security is considering, it's okay to call them and tell them that. Records to provide. Okay, so I said Social Security will gather information from your medical providers, from your IEP, from school district. But there are a lot of things that Social Security won't ask for that can be really helpful in a case. Number one, seizure log. If you are an individual who is having ongoing seizures, it's really important to keep track of those. Contemporaneous evidence concerning seizures when they occur is absolutely the best evidence, which will establish that you either meet a listing or you're unable to work. Okay. A medical source opinion regarding the listings. I actually have forms which set forth the criteria that I talked about for the adult listings, that if your medical provider is willing, they could complete and you could send to Social Security. Social Security won't reach out to your doctor to ask them about whether you meet those criteria. So that's something that we try to do if it appears that an individual's condition meets a listing, is try to get something specific from their treating neurologist. Or just primary care provider. A medical source opinion regarding functional limitations. So again, if you don't have seizures of the requisite frequency to meet the listing, you might have just additional limitations given all your problems, which would prevent you from working. And Social Security gives special attention to the opinions of treating physicians. Statements from friends and family explaining why you're disabled. Social Security won't reach out to friends and family, but we always try to get information from a parent or a spouse which established disability. And employment records. Whenever a client comes to me, I ask them, during the time that you were working, were you having any problems? Did your doctors fill out a FEMLA form which showed that you were going to be absent from work during a period when you had a seizure or during your recovery period? Or did you have performance evaluations? A lot of times we can show that this individual for 10 years got these stellar evaluations, and then when they began experiencing debilitating symptoms, their performance really decreased and they began to have problems, put on plans and things like that. And so I think that's something that Social Security doesn't see in every case, but really can show this individual can't work because the last job they had, they worked as long as they could, their performance suffered, and that's why they can't work anymore. This is not, this is not an exclusive list. We try to, talk to clients and think about creative ways that we can establish disability given the types of information they might have in their case. If your application is approved, you'll receive a letter from Social Security indicating that you meet the medical criteria. You may receive a direct deposit. Sometimes people receive money before their letter. Pro tip, if you get money, that means Social Security found you were disabled. You will receive something called a notice of award that will tell you, okay, here's the monthly benefit you're entitled to, and here's how we calculated your back award. If your application is denied, file an appeal. If you believe you're disabled, absolutely file an appeal. Appeals, any type of an appeal, even an SSI appeal, can be filed online at ssa.gov, or you can file an appeal at your local field office. I recommend that you file an appeal online so that you can prove that you filed the appeal just in case something goes on. Social Security just has so much paper that they're dealing with in their local field offices that they regularly lose things. So I'd never recommend just giving someone at the field office a piece of paper. They do the absolute best they can. They just have so much going on that if you can create a trail, that's the best. There's a 60-day deadline for appealing almost any denial decision issued by Social Security. And that's from the date of receipt of the decision, not the date of the decision. So technically it's 65 days. You're getting a call. I'm not going to spend a whole lot of time talking about the different levels of appeals. The next level is a request for reconsideration, which is kind of a do-over of what you did at the initial application process. You can see that 89% of these reconsideration requests are denied, so don't feel bad if yours is too. That's just what happens. It goes back to the same part of the agency that considers your case the first time. The request for hearing, people are more successful. 45% of claimants are allowed at hearing, but if you have to file a request for hearing, the average wait is 17 to 18 months to get a hearing from the date that you file the request for hearing, not from the date that you applied. So that's why it's important. The initial application, get all that information Request for review of hearing decision, only 14% of cases are overturned on appeal. So that initial application is really important. You may be successful at the hearing level, but you have to figure out how to kind of make it for a year and a half. Do I need a lawyer? Maybe. If your condition definitely meets a listing, like if you have strong evidence from your physician that you have seizures that meet the frequency criteria and you're complying with treatment, you may just want to go ahead and file your application. You don't necessarily need an attorney as long as you can establish those seizures occurred. Good reasons to get a lawyer are if you have a really remote work history, because sometimes we have to establish disability began 5 years ago or so many years ago, or if you have earnings since the alleged onset date that you need to explain. It's a good idea to get an attorney at that point. Or if you have difficulty with paperwork, or you just have difficulty tracking things, you're overwhelmed, it might be a good idea to get a representative. Most lawyers will get involved with initial applications. Some won't. Most will agree to represent clients beginning at the reconsideration stage. At my firm, we get involved at any time. Attorney fees are contingent on a favorable decision, so if I do work on the case, I can't charge a client a fee unless we win. Fees are generally capped at $6,000 or 25% of an individual's back award, whichever is less. A Social Security attorney can't ask you for a payment out of your ongoing benefits. They only receive benefits out of a back award. And if you have questions, I do Social Security, so do my law partners, Victoria Chuggin or Leanne Martinez. Our address and phone number are here, as well as our website and email. And if you email me, I'd be happy to send you this presentation. Any questions? Yes. Hold on just a second for the microphone. Thank you. People think they talk loud. I know.
So for those who have been awarded and they're transferring into their adult age, is there a limitation of how long if they're permanent disabled, then they are being stable and it's a seizure disorder,
Mm-hmm.
and they want to try to do some work and maybe they have some part-time work and it's affecting their SSI income. Is there some sort of established rule as to whether or not their Social Security, their SSI can be taken away from them?
Well, at age 18, there's always a redetermination. Sometimes it doesn't happen right at 18, but for a child who's been receiving SSI, they'll receive it's an age 18 redetermination, because the rules for children and adults are slightly different. So there's always going to be a redetermination, even if the condition has remained exactly the same and there's no change in the severity of the condition. So that's the first part. Second part.
But the part, once they've transferred into adulthood,
Yeah.
is there a time in their adulthood that it's redetermined and could be because they've been stable? Maybe it was due to surgery, maybe it was due to better medication, maybe it was
Yeah.
due to whatever.
Yeah.
Is there any time during a redetermination in the adult can good health, or say a window of moment of stability, jeopardize someone's established disability?
Social Security can redetermine eligibility at any time. And especially if a person is trying out work activity, that will show up on their earnings record, and that is definitely a time when Social Security is probably going to revisit their benefits, especially if they're in their 20s. They are going to probably start, send out a questionnaire about their work activity and try to get information about medical condition. But work activity is not necessarily going to result in them being taken off benefits. Now for SSI, again, that's a program that's based on financial need. So if the benefit amount is about $750 a month, and for earnings it's kind of a 2-for-1. So if an individual is working and earning more than about $1,500 a month on average, they're not going to be receiving any SSI just based on their earnings. Okay, so SSI is reduced based on any earnings. If the earnings are less than that and they're receiving ongoing SSI, reduced because of their earnings, they still might get a notice from Social Security asking for redetermination. Also, one thing to bring up is if a younger individual works for a while, they may get shifted from the SSI program to the SSDI program because they've earned some benefit at that point. So that's something that can happen for kids, especially, you know, kind of who have some work that they can do and they're working into their 20s. Hopefully,
Thank you.
there's more information about work activity, but that's kind of in a nutshell. Any other questions? We have a couple more minutes. 1 minute. Thank you.
If a person is volunteering, does that look like they're highly qualified enough for working?
No, not necessarily. Let's say you're volunteering and you're volunteering 8 hours a day, 5 days a week, and you're doing exactly the same thing that an employee is doing. In that circumstance, yes, you know, you're essentially performing work activity. But if you're volunteering less than that, or if you're not volunteering kind of the same way as an employee might be, that's not necessarily going to prevent you from receiving a finding of disability. And it's definitely not, it's not SGA, it's not substantial gainful activity, because you don't have any earnings. I always try to use volunteer activity to show what a person is actually capable of. So I kind of try and turn that around and say, this person is volunteering the absolute most they can, but they maybe are still having these problems. Like they can be at work, you know, or at their volunteer activity for 4 hours, but they need to rest several times kind of during the period that they're doing that work activity. Or there are some things that are confusing for them. So I kind of like it when my clients are volunteering, because it gives us kind of something to talk about in terms of what they're capable of. Yeah, it doesn't necessarily prevent you from receiving disability. All right, I think that's probably my time. Thank you very much. I will stay and answer questions later after the next presentation.
Great, thank you, Amy.